As you're probably aware, the Supreme Court ruled 6-3 last month, striking down New York's proper cause requirement for obtaining a concealed carry license in New York State Rifle and Pistol Association versus Bruen. The case brought together some unlikely allies in challenging New York's law. Several progressive public defender organizations like the Black Attorneys of Legal Aid, the Bronx Defenders, and the Brooklyn Defender Services filed an amicus brief in support of the NRA's brief. What brought together such strange bedfellows in this case involving the Second Amendment? I'll discuss that in this video. I'll explain the Supreme Court's ruling and discuss how it may affect gun laws in the District of Columbia and Maryland. My name is Joseph Scrofano, and I'm the founder of Scrofano Law PC, a criminal defense firm that represents individuals under investigation or charged with a crime in the District of Columbia, Maryland, and Virginia. In Bruen, the Supreme Court held that New York's proper cause requirement violates the Fourth Amendment by preventing law-abiding citizens with ordinary self-defense needs from exercising their Second Amendment right to keep and bear arms in public for self-defense. The heart of the case deals with the issue of whether a state can be a shall issue or may issue state when it comes to issuing gun licenses. New York, along with 6 other states, prior to the case were considered a may issue state when it came to issuing licenses for concealed carry permits. Under the may issue regime, regulators and government officials would only issue a concealed carry permit if the applicant could demonstrate a special reason or proper cause as to why they needed a permit for self-defense. Some of you may remember that DC had a similar restriction up until a DC Circuit case, Bruen, that struck down DC's special reason requirement in 2017. Ironically, at the time of Bruen, the DC Attorney General, Karl Racine, intentionally chose not to appeal the decision to the Supreme Court for the exact outcome brought on by Bruen, the invalidation of the entire may issue regime across the country. So, why did notable progressive public defender organizations in New York side with the NRA and file amicus briefs supporting overturning of New York's gun restriction? They argued that the gun licensing regulation was in effect a discriminatory policy. These groups represent hundreds of indigent people per year who are criminally charged in New York for gun possession. Virtually all of their clients are Black and Hispanic. They state, quote, "For our clients, New York licensing regime renders the Second Amendment a legal fiction." The brief further argued that the regulation effectively criminalizes gun ownership for racial and ethnic minorities based on its enforcement by police and prosecutors. And the thing is, the arguments made by these progressive public defender institutions in New York are entirely consistent with my experience defending criminal cases, particularly gun cases, in the District of Columbia, which is another large city with strict gun laws. These laws disproportionately criminalize, jail, and punish overwhelmingly African American communities in the city, and in many cases, the conduct that often leads to arrest, being held without bond, and oftentimes sentenced to prison or convicted with a felony simply involves gun possession with no other criminal activity alleged. In DC, the crime of carrying a pistol without a license is a felony offense punishable by a maximum penalty of 5 years in jail. Now imagine you live in a dangerous neighborhood and feel unsafe. You don't trust the police who have for years terrorized your community, so you seek out a firearm to protect yourself and your family. Maybe you even go across the river to Virginia and legally purchase the gun. However, because of strict licensing regulations, you cannot register your firearm and obtain a concealed carry permit because you have to demonstrate to the government that you have a, quote, special need for self-defense. And DC's pre-Bruen regulations, like the New York law, did not recognize living in a dangerous neighborhood as a, quote, special reason. Now imagine you later get arrested for carrying a pistol without a license, charged with a felony, potentially held without bond, lose your job as a result of being in jail, and ultimately get convicted for a felony because there's no real defense to not having the license. Now you are forever barred from legally carrying a pistol because you're a felon, you still live in a dangerous neighborhood, and now you slip further into poverty because your job prospects as a convicted felon have greatly diminished. This is the reality in large cities with strict gun laws like DC, New York, and others. The police and prosecutors disproportionately use gun laws to criminalize conduct in minority communities that would otherwise be considered common in predominantly white suburban and rural areas. In the brief of the Black Attorneys of Legal Aid, the Bronx Defenders, and the Brooklyn Defenders lay out in particularly painstaking detail the systematic oppression that New York's gun laws wreaked on their clients. And these stories include specific clients they've represented. One is Jasmine Phillips, a combat-decorated Iraq War veteran who visited her family in New York from Texas. While parked, New York police surrounded her vehicle, opened her car door, put her in a chokehold, handcuffed her, and then claimed they heard a tip that she had an illegal firearm. She was arrested, charged with violating New York Penal Law 265.033, which, like DC's carrying a pistol without a license statute, is considered a violent felony to possess a firearm outside the home without a license. She was held in Rikers for weeks, unable to post bail, lost her job, lost her home, and eventually lost custody of her children due to a Texas judge citing her violent felony arrest in New York as a basis to deny custody for her children. The brief describes numerous other situations faced by specific clients who ran afoul of New York gun licensing regulation. Again, this is the reality of large cities with strict gun law. In the suburbs, you might see a white guy open carrying in a subway and no one bats an eye. If you live in a predominantly black community and are caught with a pistol, you are arrested, jailed, charged, and often convicted of a felony offense. So these public defender organizations urge the court to side with the New York NRA and strike down New York's special reason requirement. What did the Supreme Court say about the Second Amendment? The court built on previous decisions, including the District of Columbia versus Heller and McDonald versus Chicago, where for the first time it recognized that the Second Amendment through the 14th Amendment protects an individual's right to bear arms for self-defense. The Heller-McDonald decisions, however, primarily focused on the possession of a firearm in the home and the right to self-defense in the home. Bruen expanded the Heller-McDonald ruling to include the right to carry a pistol outside the home for self-defense. Now, in my view, this was a correct decision that invalidated arbitrary restrictions on a constitutional right that were often used in a disproportionate and discriminatory manner by punishment bureaucrats in large cities. My experience defending clients from DC's restrictive gun laws is completely consistent with the compelling arguments and tragic personal stories the progressive public defender organizations eloquently described in their amicus brief. In short, gun laws are racist, and so good riddance to the entire May issue regime. That said, the Supreme Court's reasoning to get to this ultimately, in my view, positive outcome is terrifying, because Heller and McDonald did not set out a clear framework to scrutinize what types of gun restrictions are constitutional. Several circuit courts adopted a two-part approach to determine whether restrictions on gun rights are constitutional or not. The first part assessed whether the regulation was deeply rooted in the nation's history and tradition. The second part of the test applied a means-end scrutiny analysis. Now, means-end scrutiny is a doctrine of constitutional interpretation that has existed for decades. It goes like this. The Supreme Court decides that a particular constitutional right is fundamental. For example, the right to free exercise of religion or the right to free speech. Once that decision is made, the court would apply what is called a strict scrutiny analysis, which means that the law restricting the right by the government must be narrowly tailored to serve a compelling government interest. The court applied something called a rational basis test when a government passes a law or restriction that does not implicate a so-called fundamental right. A rational basis test requires the plaintiff or person suing to show that the law or regulation is not rationally related to a legitimate government interest. An easier way of looking at this is when the courts apply strict scrutiny, it's very likely that they will strike down the regulation as unconstitutional, and when they apply rational basis, they are very likely to say that the law or regulation is constitutional. Now, imagine a state government passes a law that says if you speak out against the government, they'll arrest you. Well, the right to free speech is fundamental, and because a fundamental right is implicated, the court would apply strict scrutiny and likely strike down the law. On the other hand, the government passes a law that says you have to wear a seatbelt. The freedom to drive without a seatbelt is not fundamental. So the court will likely apply a rational basis test, and the regulation would ultimately be deemed constitutional. What makes the reasoning in Bruen so scary is that the court wholesale abandons means-end scrutiny as a doctrine that has been around for a century or so. Instead, it holds that the only test for whether the government can restrict the Second Amendment is if the restriction is deeply rooted in the nation's history and tradition, which leads to a great and proper outcome that expands a constitutional right. However, the problem with this approach is several-fold. First, it turns constitutional law and litigation into basically lawyers arguing about history. And for the record, lawyers are not historians. Our expertise is in applying logic and facts and making compelling arguments, not pontificating on the historical interpretation of primary and secondary source materials like history professors do. The second and most obvious problem with this approach is that there are lots of not so great things deeply rooted in our nation's history and tradition. Slavery, segregation, denying women and non-landowners equal rights are things arguably deeply rooted in our nation's history and tradition. In addition, many things deeply rooted in our nation's history and tradition were deeply rooted in the first place because only one group of people, white landowning men, were part of the decision-making process. If anyone out there, like me, supports the expansion of constitutional and civil rights for the people while simultaneously supports limiting power of the government, this decision, although a proper expansion of a fundamental constitutional right, sets out a new doctrine for interpreting the Constitution that can easily be used to restrict the rights of citizens and expand government power, which is exactly what we saw in the decision overturning Roe versus Wade, which is a topic for an entirely different video. The decision's reasoning is also somewhat tortured in that by eliminating means-end scrutiny analysis, it elevates the Second Amendment above all other constitutional rights, while for decades the Supreme Court has chiseled away at important fundamental constitutional rights like the right to be free from unreasonable searches and seizures, the right against self-incrimination, the right to a speedy and public trial, the right to a jury trial are just a few rights that the court has limited over the years. Rights contained in the 4th, 5th, and 6th Amendments of the Constitution are arguably the most fundamental rights because they restrict the government's ability to take away our actual liberty. The Second Amendment is useless if the government can arbitrarily throw you in jail in the name of expediency and being tough on crime. Bruen has fundamentally expanded the Second Amendment. Subsequent to the decision, Maryland's Governor Larry Hogan immediately ordered his administration to cease using the proper cause or special reason requirement for issuing wear and carry permit. That means Maryland is no longer a may issue state and is now a shall issue state. The impact in DC will take much longer to assess. As I previously mentioned, Wren, a DC circuit case, struck down DC's special reason requirement in 2017. However, DC has a suitability requirement that is ripe for challenge under this new Bruen framework. DC requires an applicant to demonstrate that they're suitable to carry a firearm, and that requirement is a discretionary requirement that allows the chief of police to basically deny anyone a carry permit who has a, quote, propensity for violence or instability. There are no guidelines for how to interpret that vague statement, which basically gives the DC chief of police unfettered discretion to deem someone a, quote, suitable person, or as often as the case, a not suitable person. Post-Bruen, this requirement is absolutely ripe for a constitutional challenge. Now, if you've made it this far in the video, thanks so much for listening, and remember, if you or a friend or loved one find yourself arrested or charged under DC or Maryland's strict gun laws, contact us today for a consultation. Lastly, if you like learning about all things criminal and constitutional law, don't forget to like this video and subscribe to our channel.